Oh, yeah, it's 12:50. Oh, And just looking at it, you've scheduled a cell hearing for myself approximately 2 days from now. Yeah, for the allegation of domestic violence. hmm Now, as I look at it, yeah, there are some rules. Now, I know you say I'm not in the military, but just looking at the military rules of evidence, yes, the admitting of the hearsay, yeah. They have what's known as a criminal law book. It might be that some attorneys that are not military attorneys have never really looked at it before. But this, when I was reading it, yeah, the actual case law, yeah. Victim statement given 30 months earlier. Yes. I didn't see a victim statement for the allegation of what happened in Sequim, Washington. Yeah. I got a traffic citation. Oh. And then the criminal complaint actually didn't have a victim statement. I just got a two-count criminal complaint that defined what the law says. Yes. hmm Now, there's a couple concerns that I have. First is the introduction. Yeah, on page 403 of 901. Yeah. The Sixth Amendment of the Constitution provides in all criminal prosecutions the accused shall enjoy the right to be confronted with the witnesses against him. Mhm. Now, this criminal law book discusses satisfying the confrontation clause through witness production. Yeah. Waiver and forfeiture of wrongdoing or by wrongdoing. Yeah. I don't think we've really used the confrontation clause in each of the court hearings we've had for 7.5 years. Yes. It seems that the court commissioner doesn't really believe that the respondent has any right to notice of court hearings. Yeah. And because of the trauma of domestic violence laws, that I should never be able to confront my actual wife that you gave custody of my sons to, yes, for the last 7.5 years because it would be too traumatic for her to be confronted. But when you restrain the respondent and you give exclusive jurisdiction and custody of my sons to the petitioner without her acknowledging receipt of the actual court order, yes. And when you use forgeries and misrepresentation on court orders, yeah, it looks like there is no confrontation clause for those that, well, call emergency 911 fire. Now, parts 2 discuss satisfying the confrontation clause. See, there's actual notice and the opportunity to confront the petitioner about the allegation of child abuse and domestic violence. Now, I know you say you have jurisdiction. Ouch! I say you don't. Now, part 3 and 4 discuss two broad categories of the Confrontation Clause cases. Part 3 discusses the law involving restrictions imposed by law or by a court on the scope of cross-examination. Part 4 discusses the law involving the admissibility of out-of-court statements. Now, this admissibility of the out-of-court statement on July 8th of 2011, yes, where Heidi abducted my sons, right, and then you admitted a statement that I had been arrested on Guam. How admissible is the arrest record on Guam? Yeah, when she wasn't a resident of the state of Washington, neither were my sons, yes, as I was not a resident of the state of Washington. Now, to satisfy the confrontation clause of the right of the state to issue a protection order, the admissibility of the out of court statement. See, when you just read that, yeah, it's kind of like what you say in court is admissible, but what you say out of court, there could be a question about the admissibility of it. Yes, yes. It's confusing, really. Out of court, in court, out of court, in court. It makes you feel like you're playing tennis or ping pong. Now let's say, okay, you admitted, on July 8th of 2011, a declaration, yes, says right here, Exhibit B, Jack, July 8th of 2011, confidential report and sealed envelope in a motion hearing with Commissioner Brent Baisden. Ex parte, when there was no arrest, where the petitioner, the minors named, and myself were not residents of the state of Washington. Yes. But you would say it is admissible in court. It's a out-of-court statement that is admissible in court because of a confidential report. Yes. Now let's say I spent the last 3 years, 2,270,000 emails. Yes. Communicating with those that are legally obligated to protect the Sixth Amendment right of American citizens. Yes. And then you had a court hearing with no attempt of service, right? Because I was not a resident. But then you had another court hearing, right? Declaration of Heidi L. Budnick. Yes. But no attempt of service, no notice or opportunity to be heard. You didn't allow me to read any of the declarations, did you? There was no rights on my part to be able to confront the witness against me that, well, what is a declaration? Pouch! And then another affidavit, declaration of Heidi Budnick on August 10th of 2011. But no notice to myself or opportunity to be heard. And then you admitted all of these declarations and confidential reports into the court record. Yes. Now, when I think of the word hearsay, okay, there's probably a legal definition different than the actual definition in the dictionary. Or maybe there isn't. But when the respondent is the only one that actually knows what was going on at the time, yeah. How the fuck is it right now that you could admit as a court without jurisdiction or authority of law hearsay declarations and confidential reports about the allegation of being actually guilty of any domestic violence or child abuse? Well, it's more than the innocent until proven guilty. I actually did 7 hours of parenting classes, and that probably proves something, doesn't it? Yes. Yes, it does. As a parent, I didn't know everything about parenting. I'm sure every American citizen, when they have children, yes, they think I know it all. I know how to raise children. I know how to talk to them. I know how to discipline them. I know what state law says. And for every parent of the United States, do you know that you can spank your children? On Guam, you can. Yes. As long as you use your hand and as long as it's on their bottom. Yep. But let's look at the capital punishment of each and every child of the United States. And this concept of using 2 fingers on their cheek, yes, seems somewhat abusive, doesn't it, right now? Because I would never hit a child, and I never hit my children. Well, let's see who had the hands, Heidi. Oh. Now, this issuance of a 1-year protection order, Judge Ken Williams? Yes. Well, there was no notice. There was no opportunity to be heard. There was no right to confront the witness against me. When you decided to give custody of my sons without me being a resident of the state, yeah. Now, does it really satisfy the necessary protections of the Violence Against Women's Act? When you served me on Guam in October of 2011, then there's this whole law enforcement worksheet. Somebody alleged to law enforcement, and I think it was Healthy Families of Clallam County, yeah, they called the police. They said, Mr. Budnick is attempting to contact his wife through a third party. Yes. But I actually went through a trial, and I was found not guilty of that. But you as law enforcement right now.